Hi and Assalamualaikum, my metric number is S70775. Today I will be presenting the key legal issues in the case of Ketapang Trading Co. versus Jembal Stadium Berhad. This case involved a high value commercial contract worth 150 million for the supply of proprietary semiconductor components, which are crucial to Malaysia's electric vehicle industry. The dispute raises several core legal issues, including whether a valid contract was formed through proper offer and acceptance, whether there was any misrepresentation during negotiation, and what the consequences are if either party breaches the agreement. To analyze this case, we refer to the Malaysian legal framework, particularly the Contract Act 1915, the Sale of Goods Act 1957, and the Consumer Protection Act 1999. These laws help us understand the rules around contract formation, product quality, and fair trading practices. We apply the ILAT method, which stands for Issue, Law, Application, and Conclusion. To structure our legal analysis, this helps us to identify the key legal questions, apply the relevant statutes, and recommend possible remedies. Finally, this case highlights a very important lesson in business contract, especially high-stake one. Legal clarity, compliance, and good faith are essential to avoid dispute, financial losses, and reputational damage.
Assalamualaikum warahmatullahi wabarakatuh. My name is Malena Nasir binti Muhammad Nasir. My matrix number is S70743 and I'm going to explain about capacity of contract. Issue: whether the initial exchange between Ketapang Trading Co. Request for proposal RFP and Jembal Stadium Berhad responsive via a Memorandum of Understanding MOU constitute a legally binding contract under Malaysian contract law. Under Malaysian contract law, a contract needs two things: a clear offer and an acceptance that doesn't change anything. If the other side adds or changes the term, it's called a counter offer, and the original offer is cancelled. This means no contract is formed until both sides agree on the same terms. This is based on height versus range and Butler machine tools cases. Ketapang sends an RFP. This was their offer. Jembal replied with an MOU that changed the price and delivered terms, and also said the deal still needed more discussion. This is a counter offer, not a real acceptance. Ketapang never officially accepted Jembal's changes, and some terms were still unclear, especially the product quality and delivery. So there was no full agreement yet. There was no valid contract at that stage. Jembal's replies was a counter offer, and Ketapang didn't clearly accept it. Also, the terms were too uncertain. So, under Malaysian law, the exchange between Ketapang and Jembal did not create a binding contract. Next, for the law of agency issue, whether the contract executed by the Regional Operation Director of Ketapang Trading Co., who lacked actual authority under internal governance policy, is legally binding on the company under the principle of apparent authority and agency law. According to Malaysian law, someone signing for a company must have actual authority, like board approval or at least apparent authority, which means they seem to have permission based on how the company presents them. In this case, Ketapang's Regional Operation Director did not get proper board approval, so he did not have actual authority, but this wasn't told to Jembal. Instead, the contract was signed at a formal event with government officials watching, and everything looked very official. So, from Jembal's point of view, it made sense to believe that the director had the authority to sign. This is similar to what happened in the case of Freeman Lawyer, where the company was still bound because it gave the wrong impression of authority. Because of this, even though the director did not have formal approval, Ketapang's action gave the impression that he did. Since Jemba relied on that in good faith, the law says that the company is still responsible. So, under the principle of apparent authority, the contract is still valid and Ketapang is legally bound.
During the contract negotiation, Jemba Sdn Bhd claimed that their component can withstand Malaysia tropical humidity condition and temperature from -40°C to 125°C, which is a critical requirement requested by Ketapang Trading Corporation. Unfortunately, when internal document Ketapang Trading Corporation performed a test on the component, the results show that the component can only be tested between -20°C to 101°C, and there are no records that can support it as claimed. A record test report written by a junior engineer raised concern about the reliability of the test equipment and suggests the test to be postponed. Under the law, Contract Act 1950, Section 18, Bracket A, relevant case law is Chin Nambi Sdn Bhd versus Tai Kim Chu. In this case, Jembai claims that drug component fulfilled critical specification from Ketapang Trading Corporation, but the result turned out to be unsupported with result and documentation. Internal document from the plaintiff and notes written by a junior engineer from the defendant show that the actual test results are incomplete and far from the established range. Since Ketapang Trading Corporation relied on this claim during negotiation, Jemba Sdn Bhd failed to correct the false impression. It appears to fulfill the element of misrepresentation based on the Contract Act 1915, Section 18, which is the positive assertion in a manner not warranted by the information of the person making it of that which is not true, though he believed it to be true. As a result, Ketapang Trading Corporation is bound by a contract that is incomplete and does not comply with the supply agreement with Jemba Sdn Bhd. To support this case statement, the relevant case law is Chin Nambi Sdn Bhd versus Tai Kim Chu because, in this case, the developer Chin Nambi Sdn Bhd made statements about the property that were not supported by genuine approval or acceptance, similar with Jemba versus Ketapang case, when Jemba make technical claims about the temperature tolerance without any data or documentation to support their claim. So, in conclusion, Defendant Act clearly fulfill the legal standard for misrepresentation under Contract 1915 Section 18. Their technical assertion which have been fulfilled to fulfill temperature requirements are a positive statement unproven by the available information. Plaintiff, which rely on this allegation during contract discussion, signed an agreement based on invalid specification. This this misrepresentation makes the contract voidable under Section 19. The case of Chin Nambi versus Tai Kim Chu supports the position of this law by demonstrating how statements that are not supported by evidence can be false statements subject to legal action.
Assalamualaikum and hi, I am Raja Binti Bazai with metric number S70654. Now I'm going to talk about the issue for the paragraph 5. So, the contract signed by Ketapang Trading Company contains several legal problems. Most importantly, the delivery clause is too vague. The product quality clause is unclear, and there is an exclusion clause that may go against Malaysian consumer protection laws. These unclear terms make it difficult to know exactly what each party has agreed to, and may make the contract unenforceable in court. In some cases, a court may even decide the entire agreement is invalid if these terms are essential and unclear. What is the law for this paragraph? Under the Contracts Act 1950, particularly Section 2A2D, a valid contract requires a clear offer, acceptance, consideration, and intention to create legal relations. This also means both parties must understand and agree to the same clear terms. If the terms are too vague, there is no proper agreement. A key case on this is Campbell versus Austin, where the court rules that an agreement was void because the terms were not clear enough to enforce. So, the application for this paragraph is in the Ketapang contract, the delivery clause says shipments to be made as production capacity permits, subject to local public holidays and seasonal considerations. This clause does not give a specific delivery dates or schedule. It allows the seller to delay delivery for many broad reasons like holidays or seasonal issues without setting any clear rules. This makes it hard for the buyer to know when to expect the goods or if a delay is acceptable. This is very similar to the Scammell versus Austin case, where the court said a contract must be clear enough for both sides to understand their obligations. Because the delivery term in the Ketapang contract is unclear, a court might decide it cannot be enforced. So this is the conclusion for paragraph 5. In conclusion, the rule of certainty of terms is very important in contract law. Contracts must be clear so that both parties understand their responsibilities. In the Ketapang Trading Company contract, the vague delivery clause threats creates legal uncertainty and may make the contract unenforceable. This shows why contracts should always use clear, specific, and objective terms to avoid misunderstandings and legal problems in the future. What is the issue in paragraph 6? The problem in this situation started 2 days before the Ketapang Trading Company contract was signed. The CEO, Datuk Seri Syarat, received an anonymous email with embarrassing photos of him and a threat that the pictures would be made public unless he made sure the jumble deal was signed without delay or changes. This kind of pressure is known in law as duress. Under Section 15 of the Contracts Act 1950, duress includes any threat involving an act forbidden by law, like blackmail or criminal intimidation under the Penal Code. If the contract was signed because of this threat, the agreements might not be valid because of the concerns given was not truly free. According to Section 19, a contract signed under such pressure can be cancelled and voidable. So what is the law of this paragraph? Duress is recognized under Malaysian contract law, especially in Section 15 of the Contracts Act 1950, which refers to coercion, forcing someone to do something using threats that involve illegal acts. This legal principle is also supported by two important cases. First case is Pao On versus Lau Yu Long, where the court explains how duress can make a contract voidable, but only if the person was truly forced and has no real choice and took action quickly after the pressure ended. Second is Universe Timeships Incorporation versus International Transport Workers Federation, where the court confirms that non-physical pressure, such as economic or reputational threats, can still count as duress. So this is the application in paragraph 6. In the Ketapang case, the threat to release private photos was serious and clearly not legal. This fits the kind of pressure described in Universe Timeships, where the courts agreed that such pressure could be duress. However, there's a problem. Datuk Sri Shadat did not report the threat or take legal action until 6 months after the contract was signed. This is important because in Pao On, the court said that if someone does not act quickly after being forced, it may look like they accepted the contract willingly. In this case, the delay weakens on the argument that the CEO had no choice and that the contract was forced upon him. So the conclusion is, to conclude, duress is a serious issue in contract law. If someone signs a contract because of threats, the contract may not be valid. Malaysian law recognizes this under the Contracts Act 1950 and past court decisions. In Ketapang's situation, there seems to be clear evidence of duress, but the CEO's delay in speaking up may reduce the chances of the court cancelling the contract. Whether the contract is voidable will depend on how the court views the threats, the delay, and the CEO's actions after signing.
Assalamualaikum warahmatullahi wabarakatuh. My name is Timothy Hamid, Nometri S70790. So I will explain about breach of contract. The issue that I will cover for breach of contract, the Jember Sdn Bhd raised the contract by failing to deliver the microprocessor under by law Section 40 of the Contract 1950.
The party may terminate the contract if the other party refuses or is unable to perform. And under Section 57, refer that a contract become void if it becomes impossible or unlawful to perform due to foreseen event. And for application, Jombas Syndrome Berhad breached the contract by failing to deliver goods, causing a major losses including 7.9 million in liquidated damages and the termination of 25 million ringgit annual contract due by lightning during a severe monsoon made by performance impossible. Ketapang entitled to terminate the contract and claim damages. And I conclude all of this, the contract between Ketapang Trading and Jembasan is valid. Jembal violated the contract and Ketapang Trading entitled to claim damages. And the next one for remedies. Compensatory damages under Section 74 of the Contract 1950, Ketapang claimed compensation for liquidated damages of 7.9 million and lost revenue 25 million annual contract which Ketapang entitled to recover actual and foreseeable losses. And the second one, reputational and consequential loss. Although reputational harm is not compensable in Malaysia courts, it may strengthen the case for higher damage if Ketapang prove loss of business, financial and trust.
In summary, the contract between Ketapang Trading Co. and Jembasan Berhad is legally valid and enforceable under Malaysian contract law, as it fulfills all essential elements of acceptance, consideration, and lawful object. Despite early uncertainty with the MOU, the doctrine of apparent authority bind Ketapang to the agreement. However, vague delivery terms risk enforceability similar to Scammell v. Austin. Jembal's failure to deliver constitute a breach under Section 40 of the Contract Act 1950, and its claim of frustration is unlikely to succeed. Misrepresentation under Section 18A further makes the contract voidable. Ketapang may seek remedies under Section 90 and 74, including rescission and compensation for financial and reputational loss.